Sir, what message do you have for the people of Barotseland and the world at large?
Well, in the first place, in humbleness and due respect to the people of Barotseland, I wish to share with you few things. Firstly, let people know that the desire and the longing coupled with efforts to make Barotseland free cannot be mistaken for any ambition, but has been a realization to come out of undesirable situation. Having said that, I wish all Barotseland citizens and the international community to know that we are not making a second declaration, but instead we would like them to understand that our assertion and our right to nationality cannot be infringed by anybody. Thus, our concern has been that constructive possession is possession in contemplation of law. Indeed, by law, occupation was a means of peacefully acquiring sovereignty over a territory, otherwise than by cession or succession. It is a condition of a valid occupation that the territory should be terra nullius. That is how Barotseland occupied Barotseland in the 12th century. In the same vein, other explanation of occupation is that according to the state practice of the colonial days, territories inhabited by tribes of people having a social and political organization were not regarded as terra nullius. So occupation was through conquest or through agreement concluded with rulers. With regard to Barotseland, the report of the Zambian Constitution Review Commission 2003 summary states as follows: the Barotseland Agreement is a successor treaty to the treaties subsisting between the British Crown and the Barotseland monarchy relating to the protection status of Barotseland prior to independence. The agreement incorporates the territory and transfers all obligations and rights of the British Crown. I repeat, the agreement incorporates the territory and transfers all obligations and the rights of the British Crown with respect to Barotseland to the government of Zambia. Failure to implement the agreement gives rise to questions about the legitimacy of Zambian government authority over Barotseland. End of quote. So, occupation of Barotseland by Zambia was through agreement. It follows then that legal axiom states that anything is made and destroyed by one and the same means. It is indisputable that the treaty was terminated. Therefore, by law, unless the treaty otherwise provides or the parties agree, the termination of a treaty under its provisions or in accordance with the present convention releases the parties from any obligations arising from the treaty. Let me repeat that one. Unless the treaty otherwise provides or the parties agree, the termination of a treaty under its provisions or in accordance with the present convention, that is the UN Convention, releases the parties from any obligations arising from the treaty. What is obvious is that there were two parties to the agreement, vis-a-vis Barotseland and Northern Rhodesia government, or Zambia if you wish. Considering that the agreement was to be the basis of relationship, it is wise to know that one of the fundamental principles governing relationship is that the party which disowns or does not fulfill its obligations cannot be recognized as retaining the rights which it claims to derive from the relationship. Only where people use law of the jungle can there be a different vision. Maybe that is where Zambia fits in. The worst experience the Barotses have had is that when they reminded the Zambian government about the significance of the treaty, the successor to the Zambian government, like the predecessor, tried to justify the breach by invoking the provisions of internal law for failing to honor the treaty, and further even killed people. Nevertheless, the United Nations Convention on the Law of Treaties states that a party may not invoke the provisions of internal law as justification for its failure to perform a treaty. Reference can be made to Article 27. So, on the issue of occupants, once the treaty is dishonored, parties to that agreement, treaty, should refrain from making each other's territory the object of acquisition by means of military occupation or by direct measure of force, and no such acquisition will be deemed as legal. Maybe this one can be repeated. Parties to that agreement, treaty, should refrain from making each other's territories the object of acquisition by means of military occupation or by direct measure of force, and no such acquisition will be deemed as legal. This language is clear, but Zambia, as a rogue state, resorted to force by using unscrupulous police force as an instrument of injustice and hegemonic dominance. Yet Zambia has dishonored the treaty and opted to occupy Barotseland illegally. Unfortunately, whether deliberately or not, we do not know. If they have been doing so for lack of understanding, then they have to know now that ignorance of law has no defense, and the law to us does not mean penal code, but all relevant norms of justice and the principles of law, including law of agreements. We know that Mr. Kaunda, as president of Zambia, used a committee to take away our sovereignty. In reality, the Barotse people are not a committee. In fact, those who assented to the Barotseland Constitution are more than a committee. 20,000 people is not a joke. What they have done is legitimate. And since our relationship had been later based on cheap and unfounded politicking, effected by the barrel of the police guns, we have taken the step in the right direction to acquire sovereignty and to consummate our liberty. What should be done or considered are the following. Workable approach. We should have a workable approach. In the workable approach, the first thing is that people have to renounce and reject the name Western Province. So you reject the name Western and be yourself and demand respect. Secondly, you reject or renounce Zambian nationality, if any. 3, acclaim the Ritunga as head of state of Barotseland. 4, proclaim Barotseland as a country with its own right. 5, declare the office of the president irrelevant in Barotseland, the king's land, considering that the office of the president does not serve the interest of the king or the people. Declare the office of the vice president irrelevant as well from Barotseland. How can we have the office of the vice president in Barotseland when we have the office of the Ngambela or Sofi? Stop recognizing the deputy minister as head of Barotseland. He represents the president and he is politically above the Ritunga. 8. Recognize chiefs as Lord Prince or Lord Princess in Barotseland. Recognize the Silalo chiefs. Recognize all relevant authorities established in accordance with the wish of the Barotse people and in conformity with our laws. Understand that Barotseland does not belong to Zambian political parties. This is how sovereignty is restored, not by finger pointing or gossiping.